Channel 5 Network, this is MorningLine.
And good morning, everyone. Welcome to MorningLine. I'm Adam Gissimi. We are asking the expert as we do, and we try to do every day. Today, we're going to be talking about medical malpractice. We have Clint Kelley from the Kelley firm in Hendersonville with us this morning. Thank you for joining us, sir. I appreciate it. We're going to be talking about medical malpractice, which has been your expertise for 2 decades now.
That's right.
Okay. Thank you for being here. Before we going to take callers, obviously, like we do every day at 737+. So start dialing if you have questions about medical malpractice, which always seems to be a pretty big topic. But for you, I guess let's just walk it through the basics. When someone calls into your office, and I know law firms get calls constantly, and you have to sift through what is a case, what is not a case. What do you have to listen for? Is it just really physicians or doctors just doing something that they should not be doing? Is that really what you're looking for?
It's a lot more than that, Adam. We get a lot of calls. Typically, we get about 100 calls a week. We may only take one case to investigate out of that 100 because the type of case we're looking for is a case where the patient has had a substantial, permanent, severe injury, a catastrophic injury. The lion's share of cases where people call, they may have a case where there was some negligent care provided, or they may even have a bad outcome where there was no negligent care, but typically they recover. Typically the lasting effect of the injury is very mild, and in those cases the patients, although something bad has happened to them, my experience is juries won't compensate in those cases. They think, you know, if you come out okay, you can live with it.
So is that the key? You have to have something that changes you for the rest of your life.
Absolutely. That levels the playing field, and those are cases where juries feel emboldened or empowered to say, I'm going to take this case seriously. I may need to help this patient go on with their life because the catastrophic consequences of the injury.
So I have friends that are doctors, and they tell me all the time, yes, if you look at my before my take home, I guess what my real salary is, it looks ridiculous, but they always tell me a big fraction of that is going to malpractice insurance. From your side of things, with people, they really have to fight in order to have protection under these kind of situations.
That's right. It seems like both sides pay a heavy price. The doctors in particular have to pay a substantial amount of money for malpractice insurance. But again, the patients have to go through so many hurdles to get compensation because the malpractice insurance carriers will hire the best lawyers and typically will defend these cases all the way to the very end before they either pay a settlement or in some cases take the case to trial. Medical malpractice cases are one of the largest percentage of lawsuits that actually go to jury trials. Most cases in other types of situations, personal injuries, those settle. Many malpractice cases actually go to trial.
So what type of cases do you commonly see? Has it changed in the last 20 years? What do you really get a lot of calls about now?
For the past 20 years, I would say the most common type cases that we will take are cases where someone has perhaps lost a limb, where there's been an amputation because of a misdiagnosis of an infection. We've had cases with patients who have been wheelchair bound because they either had an infection in their spine or there was some brain damage cases. We've had many of those, and those can often be the worst type cases where the patient simply can't take care of themselves.
Sure.
Or the loss of an eye. I've had a case where a lady was rendered blind as a result of a sinus procedure. So those are the typical type cases we take.
I know every case is different, just like all the cases that we cover, News Channel 5, but is there any common thread? I mean, is it always doctors just not doing what they're supposed to, acting negligent in some sort of way, or is it just everything is so unique every time you start working on one case?
I think everything is unique. I would say if there is a common denominator or thread to these cases, it's the failure to communicate, particularly between nurses and doctors. Important information about the patient not being passed on through the chain of command so that the doctor can make an informed choice. Many times it's my experience that the doctors do an outstanding job providing care for patients, but they can only deal with the facts on the ground as they know them. And if they don't have all the information about the patient's condition because a nurse has failed to provide that information or has perhaps not thought the information was important, those can have major consequences for patients because the doctor doesn't know what type of care to provide because he doesn't know what's going on.
Sure. And it's all just like so many things in life, it's all about clear communication.
Correct.
We're going to go to Donna holding on line 1 now. Donna, good morning. Can you hear me?
I've got two quick questions. I wanted to differentiate because one has nothing to do with the other, so I don't want there to be any inference in that. And one is not exactly medical malpractice, but because it doesn't rise to that level, but I'm looking to what I could do, and I think maybe you guys could help me. I'm trying to, I was hospitalized for some surgery on another, and one of the questions that the anesthesiologist asked, well, what he said was he was looking at my medical record, and he said, I can see you have, and I don't remember if he said muscular dystrophy or multiple sclerosis, but one of the two, and I just about jumped out of the gurney because I don't, and I said, where did you get that information? And they kind of backed off, and I still would like to track that down. And the second thing is, I have another issue that does not, partly because of my having senior guests on other programs and knowing what the chances are of prevailing in a medical malpractice situation, I'm not going to pursue in that area, but I have already been to court and asked for this information to be placed under seal. And this isn't what it is, but just to give you an example of something that it could be. Supposing that my medical record at some point reflected that I had AIDS, that is something that could, again, it's totally untrue. So, or an STD, or you name it, something that someone with access to my medical records could use for some unsavory purpose. And again, the matter that is the case is fully not true. As I said, I have filed. It is that I've been given a temporary seal, and the attorneys on the other side have come back and demanded a jury trial.
Okay, let's let Mr. Kelley kind of attack both sides of that. So,
right.
Let me start with the second one. You're not the first to have brought up an issue like this before where there has been either a misdiagnosis or simply some erroneous history that has found its way into the patient's medical record. And I've had a potential client come to me and say, Mr. Kelley, what can you do? How do I scrub this off? And the short answer to the question is not much. You can go to the medical provider who put that information in the chart and ask them to make a note that it was an error. If that error is continued to be reported in the records and is used by a subsequent healthcare provider to a point where you're injured or you're wrongly treated, you are going to have a good lawsuit to be able to bring against that first healthcare provider that made that error. And all healthcare providers want to get the information correct. The second question regarding the muscular dystrophy, or why the anesthesiologist asked you that, he may have seen something in your history or your background to make him conclude that that's possibly what you had. And you have to remember, anesthesiologists have to know as much about your history as they can in order to make sure they give you the proper anesthetic. And obviously, as a patient, you can clear that up and let the physician know that that's not what you've had in your background. But in terms of sealing your records, you can get some help from the court in that regard. But remember that the physicians and the hospitals have an obligation to report what they believe to be your diagnosis or your history, because if they don't, and you're mistreated by a second doctor because they don't know about that history, then the first provider could be held liable. So always keep that in your mind.
It's all a circle.
Right.
We're going to go to, well, Donna, first, thank you for your call. We're going to go to Natasha now, holding on line 2. Can you hear me? Good morning.
Good morning. Yes, I can.
Go ahead, ma'am.
My question was just how long do you have to file a malpractice suit?
That's a very good question. You have 1 year from the date that you were injured, or 1 year from the date that you discovered that you were injured. So, for example, if a physician burned you during a surgical procedure and you woke up the next day and knew that you'd been burned, then you would have 1 year from that date of being burned in which to file what we call a notice of intent to sue, which is we'll talk about this a little later, Adam, but it's basically a letter that you send to the physician saying that we may end up suing you for what negligence occurred during the surgery. The second type situation would be, say, for example, you had cancer and it was misdiagnosed, and for a period of 6 months or 8 months, or let's just say on the 10th month, you found out from another physician you do have cancer and it was missed. It should have been diagnosed 10 months ago. You would have 1 year from the date you learned that you had cancer in which to file a notice. So Tennessee will allow you 1 year either from the date of the injury or for the date of discovery of the injury. One thing I also want to remind you, we have what's called a 3-year statute of repose, and that's just a fancy word for saying that 3 years after the negligent act, if you wait after those 3 years, you've got no claim. Unless they leave an instrument in your body, which is an exception to the rule, or unless there's some fraud involved, if you don't bring your claim within 3 years, it's gone.
So it's almost a statute of limitations on this type of.
That's correct.
On this type of case. So, okay, we are going to take a quick break, but for those folks holding, continue to hold. If you want to ask any questions about medical malpractice, please call us 737+. Morning Line will continue right after this.